concomitant sequitur that the DNS allowance also must be under those rules.
See the details.
And please see, Manoj, they expressly refer, consequent upon revision and pay allowances of state government employees with effect from 1st of January 2006 under the...
Even the areas are according. Even the areas are according.
Yes.
The question was purposely put to both of you.
Yes.
For you to respond to.
Yes. No. Now, Manoj, let me answer that question. Manoj, once you have rules...
So according to you,
yes,
there are rules spreading the fee. Therefore, the exercise of the power has to be and is in fact adoption rules. That's just
that is the answer. In other words, Manoj, there is no residuary executive power which is vested in the governor to either bypass the rule or improve upon the terms and conditions. Manoj, that doesn't exist once it is covered by the rule. And Manoj, it is also common ground that these employees were in fact governed by the ROPA rules. So we have within the ROPA rules, these Manoj were clamoring for this determination of DNS allowance, and we have another set who are being granted exactly as per the central government deed. Now, Manoj, the point is, this formula, Manoj, the reason why I mentioned 3C3, appropriate, the word appropriate means that it is based upon this index. This index, Manoj, is a base. 536 is a base, which is why your lordship saw in the chart, in the entire chart, every calculation has 536. So, therefore, Manoj,
one more.
Sorry.
Worry which comes to
Please,
my mind.
please.
Is this page 126 document?
Yes.
In exercise of the discretionary power vested with the government under OPA?
Manoj, the discretionary power, incidentally, Manoj, no, because under the ROPA rules, may I show your lordship's rules 12 and 14, because, Manoj, they actually have overriding effect. Because they have overriding effect, you cannot have anything supplement because of rules 12 and 14.
What you are saying is any which way.
Yes.
Any which way.
Yes.
This is under OPA.
That's right.
And therefore, section 3, Roman 3 has to be read, the contact in the background and the control.
Now, in other words, Manoj, now let me put it the other way. How is it, Manoj, now the state could have said, for them, Manoj, they have said that this is a different, they're living in Delhi, they're living in Chennai. But let us look at it differently.
Because the cost of living in these two cities
yes.
is obviously higher.
Yes.
Manoj, let us that is true, Manoj, but then they are state government. But the point is slightly different. The point is, Manoj, 3C3 contemplates a determination. That determination, Manoj, has also been worked out. What I'm trying to say is, it is not that there was only one way they understood this rule. It is not that they understood this rule only in the way it has been preached to us, namely that it was frozen and I have discretion thereafter to give you what I can and when I can. They, in respect of these employees, in terms of both the working of the formula under 3C3 and the time for which they gave it, this extensive period of time, until Manoj finally the tribunal said this was discriminatory and the High Court struck it down. My friend said we have not appealed against that portion of that order. Fair enough, but the fact remains, we are looking at a period, Manoj, which is up to 31st of December 2019. That period cannot be effaced. The period from 1st of April 2008 to 31/12/2019, which is covered by the ROPA rules of 2009, this persisted right through. And if it persisted right through, it is not a circumstance to take into account that is it really possible that the state government did not know how to work out, shall we say, the DNS allowance payable. And Manoj, it is also not their case that this DNS allowance which they gave to these employees in Bonga Bhavan and these are not based upon the working of that 530 539, 536. It is also not their case, my lord. It is not a case that they have adopted a formula central government, but the point is, at no place, my lord, has the state said that if you calculate appropriately in accordance with the All India Consumer Price Index, IW, the result would be the rate which we have asked for, which was determined by the central government. And my lord, AICPI, that rate, is a yardstick. It's a norm. But if you embrace that norm, you must abide by that norm. Well, in terms of even, it's not only a matter of good governance, but as a matter of law, if you embrace a norm, as you're holding out, you are stopped from suggesting to the contrary, because there is a rule. And that is why, my lord, this is an obligation under a rule. And since it is an obligation under a rule, it is a statutory obligation compellable by mandamus. Now, my lord, an argument was raised. How can the tribunal do some quick footwork and come to this conclusion and issue these panoply of directions? My lord, really, that was done by the tribunal in respect of, my lord, a vexed question that should they get it twice a year or should they get it once a year? And, my lord, there was silence. There was nothing very clear. They said the way in which even this dearness allowance has been released partakes of an ad hoc and whimsical character. And if it is ad hoc and whimsical, it is important that there should be some norms. Whether it is once a year or twice a year, we suggest it should be twice a year. The Bay Commission said twice a year. The rule, my lord, doesn't forbid twice a year. And, my lord, as a matter of fact, in that document of 23rd of February 2009, your lordships will see they've also given it sometimes when it pleases them, twice a year. So, my lord, this is the point. They cannot be, my lord, surely the arbiters of destiny when it is not only a matter of contract, but, my lord, an employee of the government, it is a matter of status, governed by the rules. Can you, and, sorry, so sorry.
Sorry to disturb you.
No, my lord, no. I was just telling my learned friend, I think it's after quite a few years, we've seen two advocates general, eminent advocates general, my lord, sitting and adorning the bench in this court. It's after quite some time, my lord.
Can you show us the language of the central revision of payrolls?
Central revision, yes, certainly.
ROPA,
Yes.
we may call it central ROPA.
Yes, yes. In
What
fact,
is the language in central ROPA
yes,
vis-a-vis the DNS allowance?
certainly.
Whether they also use this index average of 5%?
Yes, yes. Yes, my lord. In fact,
And whether there is any reference to AICPI in the central rule?
yes, my lord, because even the latest 3%, which was announced yesterday, is based upon, my lord, the AICPI index point moving upwards. And, my lord, it moved actually, my lord, the basis has slightly changed, but it is AICPI.
AICPI is mentioned in the rules itself, or AICPI is mentioned in the notification?
Separate, my lord, I will, for the
The
central
word
government.
PA is given and incorrect.
I'll just verify it, my lord, and then make an accurate statement. But I'm very grateful, my lord, because the central government, my lord, is also a government. It is a government established under the constitution and our federal setup. And, my lord, it also follows a method. Sorry, I'm so sorry. Well, I'm deeply grateful to my Lord Justice Mishra. We have the rule, my Lord. I'll just hand over copies of it. This is, my Lord, the Central Civil Services Revised Pay Rules of 2016.
You have copies?
Yes, my Lord. We just get it, my Lord. My Lord, this expression, existing emoluments, occurs even in these.
Index provided?
Yes, yes.
Can we just read?
Yes, yes, my Lord.
Can we borrow your laptop?
My Lord, may I read out first?
Can we just borrow it?
Please. Existing emoluments, and your lordships will find.
Is it parameter? I presume?
Parimateria, my Lord, it has an index average.
No, but this denominator at index average 536 is not mentioned.
Which one, my Lord? But that is because, my Lord, this index average is this AICPI, IW average.
Yes. As long.
Over 2016, please. I have actually brought the earlier rules, which are the 2008 rules, my Lord. In that, your lordships will find it expressly refers to the index average 536. I'm grateful to my president.
Index average depends on the period when it is considered.
Yes, because
That's
So because this narrows down to
completely.
consideration
Yes.
whether AICPI is only a method of calculation or AICPI itself is central DA.
I'm deeply obliged. I'm deeply obliged.
Whether we
Yes.
understand the word AICPI to mean central DA, the rate of central DA.
Yes, it happens not to be the same. Because if you work on that formula,
Yes.
you will get at the same.
Because the language is the same.
Yes.
They say, according to the West Bengal government,
Yes.
this definition of existing emolument
That's right.
excludes application of AICPI,
That's right.
according to them.
Which is why I wanted to show you what this rule is. This rule is identical. So, Milord, what this implies
Now, be
is,
ready, you have to answer this.
yes. So, Milord, what needs to be understood is that this is therefore, Milord, an evolving. Milord, when we say index,
You have not developed your case.
which one?
You have not developed your case like this. You means your.
Milord, I must say,
when it comes from the court, we have to answer.
Milord, with respect, Milord, I'm obliged. To be very honest and Milord, to be candid, I did not think through this point. I'm obliged. I'm being honest, Milord.
No, just it's a way of thinking. It may not be.
No, but,
completely
no,
applicable.
but the important point is, which your lordships asked me is, that what is AICPI and is this index, this average indexing, does not this word, both average and indexation, they have meanings.
Then now comes the question,
Yes.
where is this enabling provision or enabling instructions available with any government to calculate the DA basing on AICPI?
Well, that is because this 536, which your lordship see, is actually only from AICPI. Well, let me explain this a little. This AICPI, Lord, is an exercise undertaken, it is not belongs to a private agency. It is undertaken by the central government itself in its two departments, a lot of consumer affairs and labor. And what they do, my lord, is this. They apply a lot of different bands. But for industrial workers, that is the basis, my lord, for this revision of DLS allowance. And, my lord, what they do is that they calculate and then they calculate what is the extent of variation. And if the variation is substantial, it's not that, my lord, they don't sometimes give it immediately after a little increase. There might be a gap between one increase and another increase. So what they do is, they actually give this percentage based upon these indices. So, below this All India Consumer Price Index, the ascertainment of this average index is a governmental function. And at this moment, it is being performed by the central government. In some of the cases which my learned friend referred to, which deal with industrial disputes, well, there are some references to dearness allowance, but government servants, well, are bound in some sense by a determination of a formula by the central government because it is an all India. Now, I am not saying, well, for a moment, that they could not have come up with another, if I may say so, rational formula. But if they choose to adopt the central government, and which is what your lordship saw, they have been doing since 1979 in the Pay Commission's report. So consistency demands that you come in alignment with it. That is what the Pay Commission recommended. So for the state government today to say that it is frozen, and after which I will only give, your lordship asked again one of the critical question, tell us what basis did you work? Where did you get the rates from? If you decided to give 2%, where did you get 2% from? 5% from? Well, there is no suggestion in any affidavit that they did some independent work for the purpose of ascertaining the consumer price index, way West Bengal, and they came to different conclusions, and their statistics were different, and they formed a model. That is not their case. This 536, well, they also acknowledge that this is All India Consumer Price Index. Well, they say, which is why your lordship saw in that note of Mr. Divan, item number 11 yesterday, he admits that this is the All India Consumer Price Index. Then, Malot, the word index, Malot, in the very nature, clearly shows it is a pointer, it is an indicator, it is like a formula. In fact, Malot, that word is now used in computer algorithmic, but it is an indicator. And why does it use the word average, Malot? Because this average of 536 was for all the 12 months which preceded that 536. So, Malot, they take a weighted average of the entire year. And that is that final figure which your lordship see in that column. So, Malot, the question is 536 within brackets 1982 is equal to 100? Does it not furnish a clear mathematical formula? That is the point. If it does, it is a formula, it is exact, it is precise, or it is not left to discretion. It is a precise way of calculating it. And, my lord, it is not suggested that dearness allowance is not for the purpose of offsetting cost of inflation. It is also not suggested that this formula, if worked as a formula of indexation, then in that case, you will arrive at proper mathematical percentages, my lord, as we have shown in that chart. And, my lord, it is not that they could not use or prepare this chart. Please take this. It is not that, my lord, they were not aware of this chart, because it was on this chart, on the basis of this calculation, they, my lord, gave those employees this particular rate. So, my lord, this is, if I may say so, the summum bonum as far as the case is concerned. Now, my lord, as far as the legal position is concerned, my lord, there were some judgments which were cited. I first want to just sum up, my lord, the principles. The first is, my lord, a report of a pay commission is entitled to wait. However, it is not binding as a matter of law on a state government. Third, my lord, the government has got discretion to accept it in part or in total, or, my lord, even reject it. It is entirely up to the state government. My lord, to that extent, the prerogative of the government, I'm not questioning. But now, the next question is, if you do have a pay commission report and you accept the recommendations and you frame rules, then in that case, and that crucial words, my lord, time to time, dearness allowance from time to time, clearly means, my lord, that this is an average index which will be moving once 536 changes its position, that number, but with reference to 536 as a base, you will calculate dearness allowance. Now, my lord, the law is if there is a rule, your lordships have said, if there is a rule and the rule obliges you to pay arrears, and my lord, one must also take into account that dearness allowance revision affects not only serving employees, it affects pensions. And that is another factor, my lord, which is why it has to be in the form of a concrete rule. The last point is, my lord, when you have a clear-cut rule, then I submit any reliance upon grace or any reliance upon discretion or any reliance even upon what is, my lord, being pleaded as financial, my lord, no government is truly impecunious, if I may say so, my lord. It would be a contradiction in terms. It would be a contradiction of the very idea of sovereign governments. But suffice it to say, well, these are matters which they have to find solutions. Well, these are matters for which they need to find solutions. But it is not, my lord, open then to the government, and your lordships have held, and my lord, there are judgments in various cases, your lordships have said, that this financial liability is an oft stated argument and is liable to be rejected when it comes to, my lord, enforcement of a rule of obligations which are imposed by law. My lord, this is the gamut of my submission. I will make sure that, my lord, our written submission is updated so that, my lord, it is presented. My lord, if there's any question your lordships wish to ask, I'll be more than grateful.
Decision will.
Yes, my lord, I have put it in the note, but your lordships may take it. I summed it up, and I don't want to read extracts of this. I know, my lord.
See, that partition
Yes.
and judgment of
Yes.
Mr. Howard.
Which one, my lord?
MP judgment,
Yes.
1956.
1954. That's right, my lord. Yes, Mandava. Let us look at that, my lord.
Yes.
I wanted to show that. In fact,
If you come to Mandava,
there is actually a sentence which helps me, my lord. Let me show.
121, compilation, page 120.
Yes, my lord. I'm just. Yes, my lord. Please look at this judgment. Well, on this judgment, if your lordships will kindly see the para which was relied on, please come, my lord, to paragraph 4. This would be, my lord, printed page 974, but it is in the compilation. Please see that paragraph 4.
Yes.
On the first question, Rule 44 of the fundamental rules runs as follows. Subject to any restrictions which the Secretary of State and Council may by order impose upon the powers of the Governor General and Council or the Governor General and Council, as the case may be, and to the general rule that the amount of the compensatory allowance should be regulated, that the allowance is not on the whole a source of profit to the recipient, a local government may grant such allowance to any government servant under its control and may make rules prescribing their amounts and conditions under which they may be drawn. Under this provision, it is a matter of discretion with the local government whether it will grant dearness allowance, and if so, how much. That being so, the prayer for mandamus is clearly misconceived, as that could be granted only when there is in the applicant a right to compel the performance of some duty cast on the opponent. Well, these are the crucial words. According to me, there is a duty cast on the opponent. Rule 44 of the fundamental rules confers no right on the government servants to the grant of dearness allowance. It imposes no duty on the state to grant it. It merely confers a power on the state to grant compassionate allowance at its own discretion, and no mandamus can issue to compel the exercise of such a power. Nor indeed could any other writ or direction be issued in respect of it, as there is no right in the applicant which is capable of being protected or enforced. Then, my lord, thereafter, it is on this basis that they proceeded. My lord, the rule is actually for a very different purpose. This is in respect of local government. It is in respect of compensatory allowance. There are words which signify discretion. But, my lord, the learned judge is conscious that if it is a duty, then it goes out of the domain of discretion. My lord, if it is a duty, then it is no longer the subject of any discretion. Incident, sorry, so sorry. You can please, my lord, don't what? Welcome.
Please enlighten us. If you come to para 3 of the report.
Yes, certainly, my lord.
What
Certainly.
is
Yes.
this before the High Court?
Yes.
What the High Court has held and what was argued in Supreme Court?
Yes.
And what is the decision of the Supreme Court?
I'm
Come
obliged.
to para 3.
Yes, yes,
Come
my
to
lord.
para 3 and then answer
I understand.
how do we
Read that para. I appreciate it. It's perfectly, my lord.
Yes.
Please see para.
and exactly equate your case vis-a-vis
Yes.
Banga Bhavan employees
Yes.
with the argument and the case which was before the High Court in para 3.
Very well, my lord. Please see. In the petition, it was alleged that the state government should have uniformly adopted the Government of India rates for all its servants and the discrimination in making the twofold slab and accepting the Government of India rates for one slab, that is for servants receiving salary over rupees 400, and not accepting them in respect of the other slab, that is of servants below rupees 400, is highly discriminatory. That the state government has a right to be treated, state government servant has a right to be treated equally with the central government similarly situated, and that every servant has these fundamental and natural rights, and the petitioner and the members of the Ministerial Services Association have a right to demand from the respondent the DNS allowance at the Government of India rates. The petitioner then prayed that declaring that all ministerial servants are entitled to the Government of India rates, the state government should be directed by a writ of mandamus or any other suitable writ of direction to cancel the discriminatory rules of DNS allowance and adopt the Government of India rates to all servants without discrimination, or in any case to provide with adequate rates of DNS allowance sufficient to provide reasonable subsistence for them. The government contested the petition on the grounds, firstly, that the claim for DNS allowance was not justiciable, and secondly, that the difference in the scales of DNS allowance adopted by the Commission and by the committee did not violate Article 14. The learned judges, Chief Justice Sinha and Bhatt, held that under the rules, DNS allowance was placed on the same footing as pay, and the claim relating thereto was therefore justiciable, and that the differentiation made between the employees of the central government and of the state government in the matter of grant of DNS allowance rested on no intelligible and reasonable basis, and that the resolution dated 16 September 48 was therefore bad. They accordingly issued a direction to the state government that they do reconsider the question of DNS allowance payable to the employees concerned. It is against this judgment that the present appeal has been prepared by the state government on a certificate granted under Article 132(1). And para 4 also.
Now, with this
Yes.
principle in para
Yes,
4,
yes.
they have allowed the appeal.
Correct. Now, my lord, please keep one thing in mind. In para 4, it is argued on behalf of the appellant that the grant of DNS allowance is a matter ex gratia and not justiciable, and that neither a writ of mandamus nor any direction could be issued with reference thereto. Now, my lord, there are two answers to what my lord, the Honorable Justice Mishra put to me. Let me apply, my lord, that Bang Bhavan and this. But, my lord, that is a case where we are two people under the same government. The important thing I want your lordships to appreciate is we are not claiming, my lord, the A on a principle of parity with central government employees. This is very important, my lord.
No, you see, but we, the destination
Yes.
which you want to reach
Yes.
is the same.
Well, that is,
the only by way of process of interpretation,
yes.
you are compelling the court or praying before the court to issue a writ of mandamus.
Well, may I say,
I want to claiming the central DA
yes,
by applying this AICPI
yes,
without mentioning that give us central DPI, central DA rate.
Yes.
You are saying apply AICPI.
yes.
But it boils down to the same thing.
Well, the result, as your lordship said, the destination, if I may say so with respect.
The only argument which can save you is that we are not playing anything over and above what the rules say.
What the rule says.
That is what your argument
Yes.
is. And if the rules permit this, then it is an enforceable thing. We are not demanding anything new.
Well, not really this. If I may say so, the fact that this coincides with the rate of the central government is not the fulcrum of the claim. In other words, Malot, if I claim parity with another person because I say we perform the same functions, then all the judgments which Mr. Divan cited would all become applicable. I am saying that this is only a matter, this is the outcome. But the outcome, the process of the outcome is the rule. In other words, Malot, the fact that I reached that destination does not mean that I actually, through an invidious process of reasoning, am claiming similarity. For instance, Malot, let's look at the revised pay structure. The revised pay structure of a central government employee, Malot, is different from the revised pay structure of a state government employee. But Malot, only for DA, this formula is there because it is only a percentage of basic pay which is given, Malot, as an allowance. Therefore, Malot, I am saying, and Malot, this is a judgment in 54. In fact, Justice Madan's judgment in Central Inland Water Revenue, Malot, it's a classic judgment where the learned judge expounds on what we expect from a state in relation to its employees. Well, it's a lodestar. And the learned judge also says that we must not lose sight of the fact that employees, this doctrine of pleasure, fortunately, over the years, we have put some degrees of constraints in it. But otherwise, the hire and fire, or shall we say, the erstwhile Henry VIII clause, that is no longer possible under our constitutional scheme. So, even though we have a federal structure, but if under 309, rules of 30, proviso to 309, they are, in fact, this is the only provision where it is subject to an act of legislature. So, until the legislature passes an act, this is law which actually operates. And because it is law which operates, therefore, rights and obligations have to be determined in accordance with that law. And I appreciate my Lord's comment that we arrive at that destination. But, that destination, if I may say so, works differently for both of us. It is only for the percentage we are the same. We are the same. But, it is a percentage of the basic pay, the revised pay. That is not an either. That is the point I make. So what is actually worth is only the percentage. And this, is a part of the expression emoluments. The reason why I'm very grateful, to my Lord Justice Mishra, as I said, I really I didn't think of the central government's rules, but those rules clearly indicate in 2000, at that period, they clearly define existing emoluments with reference to this wage. So, this, if I may say so, is the farthest I think I can see.
Do you have that notification by the central government?
Yes.
Sanctioning PA by applying AICPI?
It
is not in the rule.
We have the state government notification.
No, we also have
central
government.
Yes.
Give it to us. Give it to us.
It is in the rule itself, that your lordship wants to see the notification.
Because rule doesn't say the word AICPI is not referred in the rules.
This is index average. May I just explain?
Index average.
This index average.
Index average and AICPI is one and the same.
One and the same. There is nothing else.
There is nothing else.
same language as
Gopal Subramanium.
it is the same language, Malot. AI CPI is
There is only one index available.
only one index average, Malot, throughout the country.
So Divan has given a document yesterday explaining what ASPI is.
Column
Yes. Yes.
Is there any notification to that effect is what we are asking? If it is so, you can give it to us after.
Yes, yes. Malot, in fact, Malot, there are many notifications of the Ministry of Labour.
Just one.
Yes, yes. Oh, yes, certainly. Certainly. Malot, I'll produce that notification, how this is calculated. And Malot, there's also a third ministry, I forgot, the Bureau of Statistics. Even that is involved in working out, Malot, these indices. But your lordships may take it. I'll produce the relevant notifications from the Government of India website in relation to AICPI and how it is. But your lordships may take it that this index, Malot, that is why throughout, even in the writ petition by the state, they took the position you are getting the Q of this All India Consumer Price Index only because of this Roman 3. That state government also,
In their note, he has mentioned.
yes,
In their note,
yes, in para 11.
and so
That's right. It expressly mentions.
they have referred.
So, Malot, this AICPI is the only way this indexation happens as far as central government and the pay commissions are concerned.
Is this
Yes, Malot, in the 2-page note,
11?
the AICPI index rates are alien to ROPA 2009, save and except only for the definition of a component of existing emoluments in rule. Yes, yes, yes. Existing emoluments in rule 31C3. Malot, existing, my learned friend is referring to in present time. Malot, existing emoluments means that the emoluments which shall exist under the ROPA rules.
That means alien, yet not alien.
Yet, that's exactly the point. Alien, but not fully alien.
Fully alien.
That's the point.
Yes.
And that, I think, Malot, is with respect a contradiction in terms.
Thank you.
I'm very grateful, Malot, extremely grateful, very kind.
May I just supplement very briefly?
No, you, please, all of you this side, we are in no rush.
Yes.
Please take as much time as you.
Because it is not going to be concluded in 5 minutes.
No, not in 5 minutes.
You will also argue.
Yes. So
Each of the principal responded.
One minute. We told you, sir, everyone this side will have your turn. So whichever, whoso.
kindly, yes, kindly allow me.
Will have your say, sir.
I won't take more than half an hour.
You may take as much time, there is no rush, we told you already.
It's so good.
But don't repeat us.
No repetition, my lord. Since your lordship is interpreting the concept of dearness allowance and dearness pay, just 2 paras from one judgment, and then I come straight to the point, on which your lordships were debating just when my friend Mr. Subramanium concluded. The compilation which they had given, please, the second judgment of the compilation, Bengal Chemical and Pharmaceutical Works, page 49. Please see that. Para 17 onwards. 4 paras I want to read. Because that will indicate and perhaps will show some light on the way your lordship will interpret Rule 3.
Yes.
Page 55, para 17. 4 paras only I will read. Before we deal with the contentions of the learned council, it will be desirable to refer to a few decisions of this court, laying down the principles that have to be borne in mind when a claim for dearness allowance or revision of dearness allowance is considered. So these are the principles which have been laid down. In so-and-so versus Calcutta tramways, it was observed. We can now take it as settled that in matters of grant of dearness allowance, except to the very lowest class of manual laborers, whose income is just sufficient to keep body and soul together, it is impolitic and unwise to neutralize the entire race by cost of living, in the cost of living by dearness allowance, more so in the case of middle class. So the concept of dearness allowance, because pays are fixed this revision, this dearness allowance in its very basis is something which keeps on increasing, because the purpose of giving this to an employee is to neutralize the rise in the cost of living. Please see the next judgment, how your lordships have further explained. As pointed out in the workmen of Hindustan Motors versus Hindustan Motors, the whole purpose of dearness allowance being to neutralize a portion of the increase in the cost of living, it should ordinarily be on a sliding scale and provide for an increase on raise in cost of living and decrease on a fall in cost of living. I pause here. It can happen, my lord, if inflation ceases and we go in, in fact we go in the reverse direction. When the formula is worked, it may even reduce. It is hypothetically possible, though practically never so as we in the world we live in today. But the issue I'm wanting to flag is, one, it is to neutralize a portion of the increase in cost of living and should ordinarily be on a sliding scale to provide for an increase in the rise of cost of living. Your lordship can leave para 19, come to para 20. In Ahmedabad Mill Owners Association, it has been emphasized that in trying to recognize and give effect to the demand of a fair wage, including payment of dearness allowance to provide for adequate neutralization, industrial adjudication must always take into account the problem of additional burden which the wage structure would impose upon the employer, and ask itself whether employer can reasonably be called upon to bear the burden. In Kamini Metals, it has been noted that 100% neutralization is not advisable, as it will lead to inflation, and therefore dearness allowance is always a little less than 100% neutralization. The following principles broadly emerge from the above decisions. Now your lordships is crystallizing what your lordships full neutralization is not normally given except to the very lowest class of employee. The purpose of dearness allowance being to neutralize a portion of the increase in cost of living, it should ordinarily be on a sliding scale and provide for an increase on the rise in the cost of living and decrease on fall in the cost of living. This is what I wanted to point out. So when your lordship will interpret this rule, this is the principle which your lordship would keep in mind, that the whole concept of dearness allowance abhors the notion of fixed allowance, because the whole concept and purpose being to offset the increase in cost of living and therefore sliding scale is the normal notion as your lordships have understood, not today, but from the very time when this concept was brought in. Now, with this background, my lord, now kindly see Rule 3. I have 4 points on Rule 3 to make to your lordships. I can start immediately after lunch because then it will be one.
How much time?
Half an hour, because I am not going to repeat what my learned friend says. Half an hour. I just want to read some parts of the original CAT and the first High Court judgment. And yes.
I'll be half an hour after that.
Okay.
So whatever time left for me,
No, you have all the time. We carried out.
I will not take that after this argument, not more than 20 minutes.
So, anyone else who's to argue this side? So we move from the mind that today this side would conclude.
Yes.
We move, and then tomorrow.
After Mr. Patwalia, will that I shall take up and.
My lord,
No difficulty. Even if you are not concluding today, we continue tomorrow. But we are just letting them know that tomorrow the hearing would begin. It would continue. That's all. Thank you.
Good.